Welcome to Boorman Lawyers. In this video we're going to discuss a low-range drink driving offence that we appeared on at the Southport Magistrates Court on the Gold Coast in Queensland.
G'day, it's Josh Boorman here from Boorman Lawyers. I just want to have a quick chat today about another matter I've just come out of at Southport Magistrates Court. This matter involved a middle-aged lady who actually lives in Sydney. She holds a New South Wales driver's licence, but she'd come up here about a month ago to visit friends and stay with them for the weekend. While she was up here, she went out to dinner. She then agreed to drive her friend's car back to where they were living. Was pulled over on Hooker Boulevard just near Pacific Fair for the purpose of a stationary random breath test, and she was found to be over the legal limit and recorded a blood alcohol reading of 0.087. So she was at the higher end of the low range category. She did have a passenger in the car, which is usually seen as an aggravating feature. And we had to obviously try and plead for leniency in this case because she does rely heavily on her driver's license to be able to work down in Sydney. Unfortunately, because she was the holder of a New South Wales driver's license, that actually precluded her from being able to apply for a Section 87 restricted work license here in Queensland. So what we had to try and do is try and plead for the maximum amount of leniency. Given it was a low range type of drink driving offence, the minimum disqualification period she could have received was 1 month off the road, but the maximum was 9 months off the road and a maximum fine of $1,649. What we did to try and mitigate my client's situation and seek maximum amount of leniency in her case was we obtained several documents of evidence from her employer to show that she did require her license to drive to and from work at very early hours of the morning, and from time to time also require her license to actually perform her job as well. We were able to get the employer to also confirm that for the time that she is going to be off the road without a license, then her hours will most definitely be cut back and it will affect her ability to earn an income. So that was obviously one big reference and piece of evidence that we were able to get to put before the court to show that any disqualification period will affect our client's ability to earn income in the future. I also went online and did some research about the area she lived in and where she worked down in Sydney, and I was able to pull up the public transport records, which were able to show that public transport in her area was non-existent in the early hours of the morning when she was required to get to work. So that also showed that our client will have to suffer further without being able to rely upon public transport. We're also able to help our client put together a letter of apology to the court, just explaining what went wrong on the night, how she thought she certainly wasn't over the limit, and expressing some of the significant lessons that she's learnt coming out of this whole experience, and also from completing the traffic offenders program. And that's another thing we advised our clients to go and do, a traffic offenders program. They have a number of courses all throughout Sydney and New South Wales, and also courses in Queensland. So she did a full one-day traffic offender program course down in Sydney. She completed a workbook, completed all the modules as a part of that course, was provided with a completion certificate, and we're able to tender the workbook and certificate before the court just to show that she's taken proactive action in order to help re-educate and rehabilitate herself in relation to driver safety. So all this was presented to the court. The magistrate at Southport Magistrates Court read through the material, asked myself as my client's solicitor what further oral and verbal submissions I wish to make on her behalf, and I strategically went through my submissions. I first looked at how the offence came about, tried to water the offence down and discuss then discuss my client's traffic record, and I really wanted to put some emphasis on that traffic record because it was the first major offence she's ever come in before the court on. It's the first drink driving offence. She's had a couple of minor speeding offences, but from a totality, a total overview of her traffic record, it was quite a good record. So I did want to present that to the court and show that this was a very out of character type of offence for my client to be before the court on. I then obviously wanted to look at some of the more subjective features about my client and who she is, what she does for work, and how a loss of license will have significant impacts on her ability to earn a living and provide for herself. Also discussed that she has a mortgage, car loans, credit cards, and other common living expenses that will obviously suffer from any period of time she's off the road and unable to earn a living. So we presented that to the court. We also just touched upon the fact that she had done the traffic offenders program, and really I highlighted the significant lessons that she took away from that course. All in all, we packaged it all together, we presented it to the court, and the magistrate agreed that for my client it was quite unfortunate that she was precluded from applying for a restricted work license, and that unfortunately she would have to spend some time off the road. And based on all the issues we presented to the court and her current situation, she was willing to reduce the disqualification period down to the minimum period of 1 month. The magistrate did say that for a matter of this nature, where the blood alcohol reading was at the higher end of the low range category at 0.087, she would usually give people a 3-month period of disqualification. However, due to extenuating circumstances and my client's situation, she was willing to reduce it the whole way down to 1 month. But she did increase the fine slightly up to $600. The other very big and positive thing that went in my client's favour was that she was able to maintain a conviction-free record. The magistrate decided not to convict my client with a criminal conviction, and that's basically kept her record and slate clean. So guys, this is we do a lot of drink driving cases in Queensland and New South Wales, and in particular Southeast Queensland. This is just another type of drink driving offence that we appeared on. Certainly it does pay to have an experienced lawyer on board to best prepare your case for you, because there is room for the penalties to be reduced if certain things are done between the incident and the time that the matter comes before court. We certainly have the experience in knowing how to present a good case before the court and advising how to best prepare the case prior to court when it comes on. So if you've been charged with any criminal offence, drink driving, drug driving offence, then please feel free to give me a call on 1300 941 900, or go along to our website, which is Boorman Lawyers, BOORMAN lawyers.com.au. There's plenty of information there around criminal offences, traffic laws in Queensland. You should probably go on there and make yourself familiar with your particular situation. Then if you want to give me a call, I'm happy to have a free first telephone consult with you and see if we can represent you when your matter comes before court. Thanks for tuning in, guys. Cheers.